Good evening. Good evening. The meeting for the Winthrop Town Council for September 16th is now called to order. Would you all please rise? Councilor Del Vento, would you pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Carrie. The beginning of tonight's meeting is focused on the open meeting law, so we've invited all the department heads, or not department heads, I should say, committee chairpersons and or their designees to come tonight. And it looks like church. Feel free to move up front because we're going to talk very, very quietly, so you'll be forced to hear it. We've had the best laid plans of mice and men often go astray. Somewhere there is a PowerPoint presentation set up for this meeting. It didn't get here. We don't know where it is. There is also a handout that we thought was printed that isn't. It is not available. So what's going to happen is I'm going to introduce Betsy Lane from Kopelman and Page. She is going to give us the presentation. It's then going to be followed up with all of the PowerPoint on the WCAT reruns. So this is being broadcast live, but as you know, it runs over and over on the TV. So that's going to be, as part of, Mike is going to put that into the presentation. The packet that we have on the open meeting law that was supposed to be a condensed packet that we don't have with us tonight is also going to be posted on the website. So without further ado, one other thing, everybody who's here representing a committee, there's a sign-in sheet at the back of the room up where Carrie is sitting. Make sure you sign in because we want to make sure that we have credited every committee that's here tonight. Those people that aren't here tonight, we're going to have to make another method for them to get this because every committee chairperson or designee needs to know the open meeting law to make sure we're all conforming to it. So,
Mr. Chairman, the website in the town, it seems like it's broken for the open meeting laws. I was wondering, when you said you're going to put it on the site, you're going to put it on CHP or you're going to put it on the town site, maybe the presentation and the
I will leave that up to the technicians
okay,
as to where it's going.
That might be, it might be more permanent.
Yes, okay. And before we continue on, could we call a roll, please, Denise?
Councilor Calla. Present. Councilor Sanford.
Here.
Councilor Boncory.
Here.
Councilor Barone.
Here.
Councilor Terry. Councilor Boyajin. Councilor Mayo.
Here.
Vice President Del Vento.
Present.
President Gill.
Present.
Thank you.
Councilor Lettieri had another commitment, and Councilor Boyajian is in California giving a presentation for his medical occupation that he's involved in. So again, please be sure to sign in so we know that you're here. And I would now introduce Attorney Betsy Lane from Kopelman and Page.
Greetings, everyone. I guess today we're going to go back in time a little bit because the plan, pardon my back. The plan was to have a nice PowerPoint and for each of you to have a set of the slides with a nice place for note-taking, and there was a miscommunication. That's a classic, is it not? But that's all right. We will pretend it's the 1960s, and we'll do it the old way. But actually, you can help me out by letting me know, are there any board chairs here? How many chairs? 1, 2, 3, 4, 5, 6, 7. Okay, I might have just that amount, and I'm going to ask for someone to be an assistant, if you'd be so kind. Make sure each one of the board chairs gets both this weighty package and the guide sheet. All right? Now, as Peter has said, this information is all going to be available on the website. And so therefore, there was, as someone said, a lot of trees have died for this, and that was not the intent. So please, forgive me, and we will move right on from there. All right. There is a thing that is called the new open meeting law. It's not that new anymore because it went into effect the first day of 2010. Those years do whiz by, but even after 4 years, there are still aspects of the new open meeting law that are foreign, not yet, we haven't yet adjusted to them, and can cause confusion. I'll give you a little overview of those. One of the interesting things about the new open meeting law is that it has made an elevated position for the chair of what used to be called a multi-member board, which is now called a public body. The chair has various duties and powers that never existed before. They have to do mainly with the agenda, putting together the agenda, and also with controlling the meeting to a certain extent. The rules about recordings taking place at the meeting are a little different. And also the chair is expected to make declarations at the time the executive session comes into effect. So these are new roles for the chair. In addition, the posting requirements, you've probably heard about this. The posting requirements, notices and so forth, are more demanding. Now, if you were to talk to the drafters of this legislation, they'd probably say, well, this is basically the way we've been doing it before, it's just enhanced a little bit. Why was there the need for the enhancement? Well, you might remember that enforcement of the open meeting law used to be done by the district attorney of the county in which you were located. This led to disparities in the way it was enforced. Some district attorneys would be lenient or understanding, shall we say, about violations. Others would be hardliners. And so what you had was a discontinuity or lack of uniformity throughout the state. This is something that can be problematic because when you have a statewide law, it's certainly desirable that that law is enforced pretty much the same everywhere. Now, because there are human beings involved, you're never going to get robotic lockstep enforcement. You know, when the Attorney General changes, for example, their office that reviews town bylaws maybe takes a little bit different point of view. A new division of the Attorney General's office was created, the Division of Open Government, and laughingly, you know, its acronym is DOG. But that was headed by a particular Assistant Attorney General. There's been a turnover since in these 4 years several times. So this can can slow down maybe developing the law on the interpretation of the statute. And sometimes it means that we can be kind of in a gray area. The way this statute was devised, it intended and stated that the Attorney General's office would create regulations for implementing certain aspects of it. Well, it took a while for those regulations to be in place, and they've been tweaked a little bit. So sometimes we find it's something that seemed like it was okay at the very inception of the new open meeting laws. Now it's been clarified, not so okay. But for example, I'll give you a good example, the posting of notices. In the old days, it was not unusual for the notices to be posted inside a building, and the building would be locked, and then therefore no one could see those notices. The new statute, the new open meeting law, and the Division of Open Government wants that available on 24 hours notice. So you may have seen across the Commonwealth that some communities have put actually a notice board in the exterior, locked, covered with glass, whatever, so that at any hour of the night or day someone could go view that. There were alternate methods that were gradually adopted and sanctioned by the Attorney General. For example, if you didn't have a place where you could have someone come and read 24 hours a day, you could have your regular posting inside the town or city hall, and then you could have the notices available at some place that's open 24 hours a day, such as the police station. So there were accommodations made, but what I've seen gradually is more and more you have the written notice, the hard copy notice posted in the exterior of the building. It took a while for the Attorney General to deal with the question of, well, what if you have the agendas posted on the town's website? That's also possible now. But the thread or the motif you're going to see going through all of this is do as much notice as possible. Do as much as possible. And that's true too with the specificity of agenda items. There's problems adjusting to the fact that the new statute wants more specificity than we were used to providing. And so that takes a little while to learn how to do it, and it also allowed the Attorney General some time to create regulations that dealt with some of the specifics. Now, the Attorney General writes advisory opinions, but even more enforcement opinions, and there, I will refer to them throughout here. It's unfortunate you won't be able to see them up on the wall, but they will all be posted. I suggest that if you have any questions whatsoever or don't have a copy of either the statute or regulations, you go to the Attorney General's website, or you just type in Massachusetts Open Meeting Law, and you will get plenty of sites where you can go to and you can print off everything. So if you have access to a computer, whether at home or at the library, you can get the regulations, you can read some of these opinions for yourself, and you can get all the information that you really need. All right, so today what we're going to talk about is several things. I'll tick off what's in the list. Introduction to the new open meeting law, which I've given you a little of. What discussions are subject to the law? What is a deliberation, quote unquote? And that's very important because that's where we can go awry, not understanding what's considered a deliberation. Why does it matter? All deliberations must be in open meetings. All right, so it's going to be very important to understand what is a deliberation. Also, email communications, that's now become a big thing. To understand the effect of an email communication, which is it is a public record and it is not allowed as part of your deliberations on a matter that's within your jurisdiction, because all your deliberations have to take place in open session. And an email's out there in the cloud or the ozone or wherever, it's not at the meeting. That's why email communications are really not allowed, with very, very minor distinctions. We're going to talk about that. Then the meeting notices, how much specificity has to be in there? Much more than there used to be required. Issues about conducting the meeting, and on that we're going to touch on the new role of the chair and certain powers that the chair has, and there's a new way of interacting with the chair in terms of the agenda, because we have to be careful not to violate the open meeting law by having deliberations about the agenda. It's a little tricky, but it can be done. Executive sessions. Executive sessions are almost the same as under the old statute. The difference is the statute and the regulations by the Attorney General is looking for more specificity in the items that you have in the agenda. More specificity. So again, that's a theme. The minutes. There is a change now in minutes. The change is that you are now required, if you are a multi-member board, now called a public body, you are now required to keep a record of everything that is presented to the board in the course of the meeting. There's some rules on what that means. They don't incorporate them into the minutes, but you have to retain them. This is a burden on the town because it's more paper to manage. And we have to be aware of that, so we have to keep those. There's always a temptation to have the minutes be too detailed, too much in the minutes. We'll talk about that, but the problem with that is the more you try to do, the easier it is to fail. You're trying to get everything down, like a stenographer. That's not a good idea. Your minutes can be very sketchy, but then you have to add things that are given to you. We're going to touch on this again, too, because we need to control what comes into us at the meeting. If it just comes in willy-nilly, you end up with this huge stack of material that you are now duty-bound to retain. Then we're also going to talk about the enforcement from the Division of Open Government, DOG. Okay, the open meeting law. What's the reason for the open meeting law? Well, this is called, that in public records are called sometimes sunshine laws. The idea is that the public, the taxpayers, and the general public, whether they're a taxpayer or not, such as the news media and so forth, is entitled to know what's going on with the government. And the tools that are used to make that happen are the open meeting law and the public records law. There's a little intersection between the open meeting law and the public records law, which we will touch on as we go further. So the open meeting law was revised at the end of 2009 and went into effect in 2010 as part of a broader revision of as part of the ethics reform bill. The ethics reform bill. From time to time in Massachusetts, and I dare say in every state, there is a move to sort of clean things up, tighten things up, make people more accountable, and that's where this came from. Now, there is a new requirement which is called a certification. We talked about this a little bit. Within 2 weeks of qualifying for office, being appointed to a position, taking office, every member of a multi-member board, now called public body, is required to do a certification. There is a form that the Attorney General provides. It is expected that the town clerk will provide these for you, but you still have to do it even if not provided. I wonder if everybody knows that when you take office, you're also supposed to be provided with a conflict of interest law, a copy of that. Now, you're also supposed to be provided with a certification paper and the open meeting law itself, the regulations that the Attorney General has created, and some educational materials that the Attorney General has created. There, on this form, you certify and you file with the Attorney General that you have received it. That's pretty easy to do. All right, so what is a meeting? What is a meeting? What isn't a meeting gets kind of tricky. A meeting is a time when there is deliberation over a matter which is within your jurisdiction. Deliberation back and forth. Back and forth. It has to happen at the meeting on a matter within your jurisdiction. If you decide we're going to talk about if we're going to have a party, a Christmas party, or we're going to go someplace for, fun and whatever, that's not within your jurisdiction. That is not controlled by the open meeting law. There are certain exceptions, though, that have to do with activities that may be within your jurisdiction that aren't considered a meeting. We will touch on those. Okay, what they exclude, so long as there is no deliberation, that it would be an on-site inspection. This happens a lot with conservation commissions. It can happen with the planning board. They're a different board of health. You want to go out, you want to look. There is an analogy I can make. If I am involved in litigation over a land use permit, sometimes the judge wants to take a view. Or you could have even a jury trial where the judge wants to take a view. You have to be careful because when you go out and view, you are looking, it's information coming in, processed in your own head, not discussed amongst the members because the public isn't there to watch that. So if you go out and you do an inspection, you either send an agent or one person, or it could be more than one person. We'll talk about subcommittees. But as long as they're looking, taking notes, not having discussion between one another, it is not considered a meeting. It could be a meeting. You could call a meeting out at a site, but you would have to make sure that it had public access and all the attributes of a regular meeting. So it can be done, but if you can't do that, then you treat it not like a meeting, you don't deliberate while you're out there. Attendance at a conference or a training program such as this. This is not a, the training part of this session tonight is not a public meeting. Because information is being imparted to you is not a public meeting. Now let's say I said something that was controversial and you had 2 or more members of some board here who, someone raised a question and another board member wanted to say, hey, we don't really do that, or we do that, and then they start discussing between themselves and trying to flesh out whether they do or they don't, or whether that's a good idea or not. That becomes deliberation, so we can't do that tonight. You see this sometimes when one board is invited to another board's meeting. The question is, are there 2 posted meetings or only 1 posted meeting? The safest thing to do is have 2 posted meetings, but if you only have 1 posted, the one that is not posted, the board that is not posted, is there as an observer. They're there to listen and take it back to a posted meeting at some other time. But as I said, you can have more than 1 meeting at the same time. There's nothing wrong with that, but they all have to be separately posted. You do have a question then of perhaps dueling chairs, who's chairing the meeting. You can have co-chairs and so forth, but it could get tricky, but it can be done, and it's done fairly frequently. So those are good examples of when You might be getting together, you might have a quorum, or I'll talk about subcommittees less than a quorum, and it is not bound by the open meeting law. All right, I'm going to cite you an open meeting law citation. The Division of Open Government, when they issue these, they issue them with a certain code, and that's a citation. The Open Meeting Law Decision 2012-69. That had to do with the Carver School Committee. It was found to have violated the open meeting law when a quorum of the committee stepped outside the meeting of the Board of Selectmen to discuss an alternative to a ballot question relating to funding a school project. They caucused. They came, they were in attendance, or maybe they posted their own meeting, but they decided they were going to go outside and have a discussion. That is a violation of the open meeting law. And there can be penalties for that. You will find, we will talk about, enforcement can range from something rather mild to something rather severe. A part of that will deal with whether the people involved knew they were in violation or should have known. After you've been told, you're expected to have known. All right, so the definition is a new definition of deliberation, an oral or written communication through any medium, including electronic mail. See how this has been modernized now? That was not in the old law. Including electronic mail between or among a quorum of a public body on any public business within its jurisdiction, unless there is an exception. Okay, including electronic. So we've got our good old email that we all use all the time. And it's like a habit that it's hard to restrain yourself. It's hard to explain to people that just because you use email for everything else in the world does not mean that you can use it for open meeting purposes. Not only is it a form of deliberation that doesn't take place at the meeting, it's also public record. And I would dare say the public record part of this is what causes more trouble. Because we all know that email kind of tends to encourage a certain informality, shall we say, in expressions. And sometimes that informality does not come across very well when it's read by people who weren't participating in it, or when it's published in a certain context or taken out of context. There's a variety of ways in which that email will really get you in trouble. But now, right in the statute and in the regulations of the Attorney General, we are told that deliberation is a communication via email. Because email is a big problem. In our office, we are getting all kinds of requests for email, copies of email. We're getting all kinds of allegations that something took place in email. Or you will hear, there must have been a discussion outside the meeting, because I know these guys are always emailing each other. That could be wrong or it could be right, but there's a suspicion that you're doing it, so that means you have to be extra careful. Can you do anything in email? Yeah, you can do minor, very minor stuff. I'll give you an example. Under the old open meeting law, a Board of Selectmen got in deep trouble with the district attorney then, because in their email in advance of a meeting, which was supposed to be about, is everybody available to go to this meeting on a certain day, it morphed, as it has a tendency to do, to a question about whether we should reorganize at that meeting. That's an agenda item. You cannot discuss, because it's a deliberation of an agenda item, by email. That has to be done in open session. A lot of this, or some of this I should say, is going to strike you as cumbersome. Yes, it is cumbersome. I will recognize that. We have to learn some new patterns here. So the question is, what can you do by email? What has been okayed by the Attorney General is distributing one way. Deliberation is a two-way phenomenon. Distributing agenda or packets, distributing scheduling information, or distributing any other material that to be used at the meeting. This is where the heightened powers and job of a chair comes in. Because of the fact that you cannot do a deliberation outside the meeting of what's going to be on the agenda, the chair has to make some decisions, and that's just the way it is. Unless, before you break up on your prior meeting, you decide what the next agenda is going to be. The Division of Open Government has been very, very strict on having everything that you're going to deliberate about be on your agenda. which means if you want to be able to deliberate on the agenda for the following meeting, you have to have an agenda item on the first meeting saying agenda for upcoming meetings. You see what I'm saying? Once it's there, you're all set up. So some of this you can make it into a routine once you get the hang of it, with how you can avoid inadvertently making a mistake. All right, so here's another example of the Attorney General's decision. Found that one individual member of the Stowe, it's public record so we can say, Stowe School Building Committee violated the open meeting law by emailing a quorum of members asking for comments on a PowerPoint. You might think that's not a big deal, right? Because it's not the decision. The committee members responding did not violate the law according to the AG because they did not reply to all. All right. If an email goes out for information, that's fine. If people start replying to all, I like it, I don't like it, that's deliberation. So you have to keep your comments. The comments can either go to the chair, and the chair makes a decision, or you can wait until you convene again in an open session where whatever the thing is an agenda item. Now, in another open meeting law decision, the Attorney General found that an opinion in an email from a committee member to a private citizen constituted a deliberation because it was copied to a quorum of the committee. This is tricky. I saw just the other day in my office, this well-intentioned committee chair was having this on this, it was a matter that was pending, it was very controversial in the neighborhood. And this chair set up a listserv for all the people who are interested and was having these discussions back and forth. Now, that's not a good idea in the sense that all the interaction about a matter that's before a board for a decision should happen at the hearing. It shouldn't be one member that's off having these discussions. And the rule on that is if there's anything of value that happens in a discussion outside the meeting, the member has to bring it back and report to everybody. It's very difficult to do if you're having these email discussions with people. But if that email discussion was copied to or forwarded to other members, which could even be out of your own control, then you can get into a situation where it's a deliberation. And what can start out as being something where you're trying to be helpful will turn into something that now you're accused of a violation, and the Attorney General, first time around, may be pretty merciful, but this is the kind of thing that after a while they feel, listen, everybody knows you're not supposed to be doing this. Okay, here's another one. The Attorney General did acknowledge that, and here's a quote, it can be difficult to determine when a communication serves an administrative function and when it contains a substantive discussion in violation of the law. That is so true, because there isn't a firm line. You can start talking about something that seems like it's just a little bit of management about, is everybody available to meet on a certain night, and then it turns into something else having to do with, do we have a deadline looming? Do we really need to have a special meeting? Stuff like that is then determined deliberation. He says, our best advice continues to be that public bodies not communicate over email at all, except for distributing meeting agendas, scheduling meetings, and distributing documents created by non-members to be discussed at meetings. So basically, the Attorney General is laying down a rule, no email, very little email. There better be a good reason for an email, and it better be basically about almost nothing. So, and again, in another decision, the Attorney General advised that to cure a violation caused by a deliberation through email, the entire email must be read out loud at a duly noticed public meeting. The entire email. Okay, what I'm seeing is a couple of things that are problems with management of email in general, but are even worse problems in the public sector. You've got the Bray line issue, all right, the subject line, and you've probably seen situations where someone you're emailing with, they keep using the same subject line even though the discussion has gone into different things. All right. In public records, for example, if you get a request for any email that mentions topic A, and topic A has been carried on to a whole bunch of discussions about other things, you have to produce that. It's a very awkward situation because you can go on to other things, and people almost never succeed in avoiding some personal comment in an email. glad to hear your mother's doing better, or something like that. That is not the kind of thing you want to have in the public record, because personal information is considered not to be shared with the public. That's why you have, one reason you have to be so careful. So, in terms of email management and document management in general, we have to be much more careful. For example, if you have emails that have been distributed to you for your information, you really need to start good management practices of putting them into folders by topic, segregating them out, because when there is a search request, and I know I'm going into public record, but you can't avoid it, when there's a search request for a public records, including all emails on a certain topic, when you have everything mixed into this huge morass, not sorted out, it can be extremely difficult on you and everybody else who's doing the searching to go find this stuff. So if you start making sure that you segregate any town email that you might have into a separate folder, so if you're ever asked about it, it will be quite clear that this email was about something trivial and not a deliberation. All right, so what can you do to avoid the pitfalls of email? Avoid asking for or expressing opinions or beliefs in an email. Again, email about almost nothing. Never click on reply all. If you're having an email about an agenda or something, just go directly to either the chair or the chair's staff, whoever's sent out the email. And then assume the email may be forwarded to unintended recipients. And any public record, assume that it's going to go someplace that you might not have intended, because once anyone else gets it, they can forward it, as you know, very easily, and it can be misunderstood. All right, so public body, I mentioned that too. That's something new now. We call it public body, we don't call it multi-member board. A multiple member board, this is the definition: commission, committee, or subcommittee, we're going to talk about that, within the executive or legislative branch, or within a county, district, city, region, or town, however created. If you were a town, there would be an exemption for town meeting members or town meeting representatives. We don't have that anymore. So that's why it says executive or legislative branch. However created, elected, appointed, or otherwise constituted, established to serve a public purpose. All right. The other day I got a call about something, and someone said, we've got this subcommittee on the charter. And I said, subcommittee of what? And he said, well, it's 2 town meeting members and it's 3 people from the public. And so the question is this a subcommittee? Who created this? Was it created for a public purpose, or was it some kind of volunteer residents want to look at charter issues and they inveigled 2 people who are town meeting reps to sit on the committee? If it is established to serve a public purpose, it could be something that the open meeting law governs. So you have to be careful about that sort of stuff. If it's a top-down, where it's created by the council, or let's say the council, because usually that's where it would come from, then that is definitely a public body. Interestingly enough, they carried through the old rule that if the committee is created by an individual, such as the manager, that is not considered a public body, because it's not advising a multi-member board, it's advising an individual. So it's like this thread of multi-member board can go through to the subcommittee if it's a subcommittee of that board. There's been a lot of confusion about what a subcommittee is, so I'll take a minute right now to talk about that. If you have a 5-member board and 2 people are going to go to a meeting and report back to that committee, if the 2 members are going to deliberate amongst themselves while they're at that meeting, that is a subcommittee that must be posted and noticed just like the full committee. Now, one of the problems you see is when you get volunteers or people just start doing this sort of stuff. The safest thing is to have the committee appoint a subcommittee and also say what their purpose is, because that keeps you out of trouble when you know exactly what your purpose is. Those are the bookends. Stay between the bookends. If you're going to go and report back, that's one thing, but if you're going to go and convey information for the body, the 5-member body, that's a different job. And so you have to be very careful about subcommittees. And just don't let them just spring up like mushrooms and then do what they do, because that can cause you a lot of trouble, because when people don't realize that they are acting as a public body, their tendency is not to act like a public body and to, get into email or to convey information that they're not authorized to convey. So it's very, very tricky situation. You want to control it. All right. Here is a ruling by the Attorney General. Found that a bylaw review committee consisting of 7 members, including the town administrator, town clerk, building inspector, planner, conservation agent, director of public health, police chief, that's more than 7 members, isn't it? Anyway, were a subcommittee subject to the open meeting law because they were created by a vote of the Board of Selectmen. Again, that passed through. Public body creates a committee. That committee is also a public body. And the AG made a comment that had that body been created by the town administrator in that town, it would not have been a public body. All right, now let's talk about scheduling meetings. The new thing is advance notice, the 48 hours notice, it's different now. Only weekdays count. Saturday used to count. So that means your notices have to be that much farther in advance. The way that the notice is posted, it has to go to the town clerk and to be in a manner that's, quote, conspicuously visible to the public at all hours, as I touched on before. So if you need to put it outside, you need to put it outside. Practical implications for a Monday meeting. What is the day? You are having a Monday evening meeting. When do you have to post the notice so that it's 48 hours in advance? We know Sunday's no good, right? Saturday's no good. Thursday. Because Monday is one day and Friday's one day. But beware, because if you post it at 5 o'clock on Friday and the meeting is 3 o'clock on Monday, do you have 48 hours? No. You have failed to meet the 48 hours, so you really have to be careful about that. The 48 hours doesn't mean 2 days more or less, it means 48 hours. All right, another new thing is the district attorneys used to be pretty lenient about this, continuing the meeting. You get to the meeting or a hearing, and I'll talk about the difference between the two. You get there, you're doing your business, things are going along, it's 11 o'clock, we gotta call it quits, we're not done. You used to be able to say, can everybody come back tomorrow? You can't do that now unless you have posted a meeting for tomorrow. That means, practically speaking, if you have any inkling that you won't get it done that night, post for the night after, or the night after, or the night after. It sounds kind of strange, but this brings to my town that I go to that it's a town, and when they have their town meeting, they arrange and they notify everybody that not only is it going to be on the first day, but it's going to be on the second, third, fourth, and fifth days. Now, we never go to the third, fourth, and fifth, but it's set up just in case. So that's something to keep in mind. As I say, the district attorneys used to be all right about that and just say, well, as long as you announced it while you were there. The problem with that is there's a really real problem there, because not everybody stays for the full meeting. So there might be people who totally intended to, or thought you had wrapped things up and left, and then it turns out you hadn't wrapped it up and there's no public notice. So that cannot be done. All right, so now let's talk about emergencies, okay? When do you not need the 48 hours notice? If there is an emergency. I bet you can guess that an emergency is more often desired to be than it actually is. One of the hallmarks, the main characteristic of an emergency is it's either unforeseen or unforeseeable. And there is a difference. Unforeseen, it just dropped on you. Unforeseeable is, well, some people foresaw it and other people didn't foresee it. It depends how smart and how much you're thinking about things. So it is supposed to be unforeseen, and it ordinarily has to do with a threat to public safety or health. Ordinarily. There could be a different example. For example, let's say some grant agency got mixed up and they sent the notice of the grant conditions and deadlines to the old town hall, not to the new town hall, and nobody got it, and the deadline's tomorrow, and that sort of thing. That would be an emergency in the sense that there's only one way that you can deal with that, which is you just give as much notice as you can. If there's an emergency, you give as much notice as you can. And you sort of make a big deal about it after the fact. You talk about it after the fact, you reiterate that you did it, You put it in your minutes of your meeting, you publicize it as much as you can that you did it and what the reasons are. Give the reasons, because if somebody objects and says, I couldn't be there, nobody told me, and it was too late and all that, if they do complain, you want to have the record available already as to the reason for the emergency and what you did, and explain it fully. It's not something that can kind of slip by. You have to assume nothing is going to slip by and protect yourselves by, there's the expression, papering everything. Well, make sure you've got a record of what you did and why you did it. All right. Now, oh yes, and here's another thing. If you have an emergency meeting, consider posting that same agenda item for the next available meeting. So that's the time when you can create the record and you can reiterate what you did. So you've got the belts and suspenders type of thing. All right, what has to go into the notice? The notice has to be much more particular than it used to be. Much more particular. I'll read you some examples of some of these decisions. But the rule is supposed to be, and I'm going to quote you here from the regulations and the law, a listing of topics that the chair reasonably anticipates will be discussed at the meeting. A listing of topics, the AG wants all the topics. Specifically, we'll give you some examples. That notice, it says, the chair. The chair is the one that makes this decision, unless it's been deliberated in a previous meeting. Reasonably anticipates. The word reasonably is a really big one in the law. What does reasonable mean? It's the opposite of unreasonable. What's that mean? Reasonable means you are applying your thinking process. It's a thoughtful process. It's not impulsive, it's not impetuous, it's not vindictive, it's not anything that's emotional. It's a mental process where there's been analysis. So the chair is asked to reasonably anticipate what will be discussed at the meeting. That means at times it may not be a certainty that something will be discussed at a meeting, and yet it should go on the agenda, because if it comes up and it's not on there, you're not going to be able to discuss it. The only thing you can do if something comes up at a meeting that could have been foreseen, it's not an emergency, you can discuss when you will put it on for discussion at an upcoming meeting, the next meeting or another meeting. If you have certain meetings where you tend to do certain things, and not at other meetings, or you know that your next meeting is just way too full, you can have a discussion of when you will put that item on. You can't discuss the item. There's a difference between discussing the substance of the matter and discussing the scheduling of the matter. All right, so on specificity, the Attorney General has a rule, and the rule is that the notice has to include sufficient specificity that a reasonable member of the public could read the topic and understand the anticipated nature. Now, there's a lot of room for debate there, so let me give you some examples. The Attorney General said that the school committee violated the law by failing to include a notice of a meeting, the name of the non-union personnel with whom it would be negotiating. So if the agenda item said discussion of negotiating with non-union personnel, the AG will say that's not enough. You have to have the name of the person. Also, in another case, the AG found that topics such as new business, old business, and executive session business, if needed, were not sufficiently detailed to do anything under those topics. If it says new business, you can't then, just on that basis, start talking about new business. You have to list what the new business is anticipated to be. Same thing with executive session. That has to be very specific, and I'll give you some more examples about that. It's kind of a new day, much, much more particular. Another decision of the Attorney General was that the school committee violated the law by failing to include specific details of a proposed vote on a town meeting warrant articles where the notice said town meeting update. All right, the notice said update on town meeting. That's like a status report. I don't know exactly what it means. But it wasn't enough to say we're going to take certain articles, all of them or some of them. AG said those are two different things. That's not good enough. And the AG recommended that it should have said discussion of town meeting warrant articles 1, 9, 10, 18, 32, and so forth, and so forth, and that to vote to recommend action on these articles. That's the level of specificity that's required. In another case, the AG said that a soil board they had one down at Freetown. The soil board hearing was deficient because it listed renewal of fall soil permits. That sounds fairly reasonable, I think. And before the new open meeting law, that would have been enough. But the AG said, no, you could have soil board, you could reasonably have anticipated which permits you were going to consider renewing, and you should have listed all of them, including the name of the applicant and the location where the permit would be exercised. Very, very specific. And then in another town, the AG said the notice that informed the public that a change to regulations would be discussed was not sufficiently detailed because it didn't say that it would be a public hearing. All right, let's digress for a second and talk about the difference between a meeting and a hearing. A meeting is a generic term for doing business that's within your board. A hearing is when the board is getting input, either from the public or for some specified people. It's incoming. The rule is that in a regular meeting, no member of the public has any right to speak. There is nothing in the open meeting law that says the public who attends has a right to speak. They have a right to observe. They have a right to see what's happening. In a hearing, it's implicit that there will be incoming information. The chair still has the ability to regulate. The chair is responsible, just like the moderator in the old days of town meeting. I know a lot of you remember the town meeting. The moderator runs the show, the chair runs the show and regulates who speaks, when they speak, how long they speak. So hearings can be many different things, but a hearing and a meeting are two different things. So the AG said, you didn't say you were going to have a hearing. That wasn't good enough. You had to have told the world that there would be a hearing because that means something to people who attend, that they know that there will be input to the board about some decision. Okay, so practically speaking, what does this tell us? It tells us that if the matter did not appear on the meeting notice and the chair didn't reasonably anticipate it, you cannot, if the matter didn't appear on the agenda and the chair couldn't have reasonably anticipated it, you can discuss it. But the AG doesn't give you a lot of wiggle room to do that. The AG now says, all right, do what you need to do. If it's not something that must be decided then, schedule it for another time. Public comment is a little bit like this. When the new law went into effect, there was a big flurry of concern. Public comment, what are we going to do about that? Because you don't know what people are going to say. They stand up and they start talking about something, and then what do? What the Attorney General has said is, that's okay. If you want to take public comment, it's tricky, but you can't answer back. They can say to you, I put up with this long enough, and I've been telling you that I need this and I need that and whatever. The only thing you can say is, thank you for that. We will note that. We will deal with that on a future agenda. You don't have to say when the agenda is because you can't have a deliberation about when the agenda is. You just say, we will deal with that in the future. The future might be the next meeting. The future might be 3 years from now. It remains to be seen because there has to be a deliberation. So, so the AG is saying, if it's anything of any moment, put it on an agenda item for later. All right, now, scheduling meetings. Scheduling meetings, some practical considerations. You might have a situation where you have a meeting notice that went out, a week in advance. You knew what you wanted to do, you got a week in advance, but things come up, and they come up before the 48 hours. You can change that notice. You can update that notice. You can put a new notice up, but it is a very good idea to say, this is replacing the earlier notice. To avoid confusion, recognize that there was an earlier notice that said one thing, and now you've got a different notice, which could be you're dropping things off. Person told the chair, I can't come. The chair can make a decision and say, okay, we're not going to deal with this topic because the person who is important to this cannot be there, like a citizen, or there won't be a quorum, or whatever. Or they have to have a shortened meeting, any number of things. So, but you can't do an update like that if you can't get that done before 48 hours before the meeting. All right, here's another decision by the Attorney General. That the Attorney General said, the Board of Selectmen did not violate the open meeting law by discussing a matter not on the meeting notice because the matter was raised by a member of the public and not reasonably anticipated. However, the board was strongly encouraged not to consider topics that may be controversial or of particular interest to the public until the topic has been properly listed in a meeting notice in advance of the meeting. The Attorney General is going to get less and less tolerant about this because there's been a lot of discussion of public input and a lot of guidance has gone out. You know, the maxim that ignorance of the law is no excuse. We are all, as public officials, deemed to be reading the Attorney General's opinions and the conflict of interest opinions and so forth. So when this information and these opinions have been going out for a couple of years, the Attorney General gets less and less, well, you're on the learning curve, that kind of approach. Okay, now, about location. The location of the meeting has to be fully accessible under the Americans with Disabilities Law. Interestingly enough, the notice of your hearing or your meeting has to also be accessible. So if you post a notice outside your building, you are expected to also post it outside the building where the handicapped access is. Interesting, but when you think about it, there is a logic there. So that raises issues then. Can you meet in a privately owned location? Do you think you can? Let's say you have some kind of a lodge or something like that, and your town hall and everything else is booked that night. Can you have a public meeting or hearing in private property? Yes. Yes, but subject to conditions, right? It has to be as accessible as any public building. And it may not be. You know, maybe some, great place, that's been around forever, and they haven't had to update its accessibility, but you can't use it if it is not fully accessible. Also, you have to be very careful. If too many people show up in the room for you to continue the meeting or the hearing, the fire code says too many people here. It's a tough situation because unless it is something that is urgent, you're really going to have to back off and repost for someplace else. You can't just everybody all troop across the street and go to the bigger room. It's not really allowed. The reason being, someone who didn't come for the beginning of the meeting is not going to know where you ended up. So that's something that you wouldn't do unless it was dire. Another thing you cannot do is you cannot close off access to the building during the meeting. If there's no custodian or there was confusion about where to go and you had somebody at the door to go here, don't go there, that's another meeting or whatever, you cannot close off that. You just have to leave the place open to the public for the full length of the meeting. Okay, so the Attorney General ruled on this. In Melrose, at the school committee, the search committee violated the open meeting law because the meeting was held in a locked area of the high school where the public was unable to gain access once some greeter left. You cannot be in locked, well, the door should be open, for one thing. It shouldn't even be closed. It certainly can't be locked. Another decision was, although the open meeting law is silent with regard to the time that meetings must be held, the Attorney General stated that it encourages public bodies to schedule their meetings at a time that permits maximum attendance of the public body members as well as the public. Okay, I used to work with this Board of Selectmen that used to alternate their meetings. One week or one session they'd have 7:30 a.m. at Town Hall, and another time they'd have 7:30 p.m. This was before the new town meeting, the new open meeting law. The theory was, I think you can see, they figured 7:30 will get people before they hit the road to commute, but that means they can't go on till 10 o'clock. So you have to be mindful of whether the time is also available for access. All right, now, public participation. I told you, you don't have to allow public comment. In many towns, there's a time-honored custom of having public comment. Public comment can be strictly limited for many reasons. If someone wants to get something on the agenda, now that we know how important the chair is, that person can tell the chair. And the chair is going to make a decision. Either he or she will put it on the agenda themselves, or they will have a discussion about it at some opportune time with the rest of the board. So, if you have it, it can be wherever the chair and the body is comfortable. It can be as short and have whatever rules you want. you know, I would be very careful, because I have seen rules that were too generous. If you say you can only have 5 minutes, every single comment's going to be 5 minutes. And then people will say, I'd like to have more time, and things like that. So keep it very small, keep it limited, and be very strict, because once you waver from those rules, it's impossible to insist on the rules later, because people tend to think you're doing it for personal reasons. And it really is very hard to justify. And remember, you cannot debate in it one way. Someone's making a comment is what it says. Output. It's giving you some information or an opinion, and it is not the beginning of a debate. The Attorney General also included in another town that the Board of Appeals was not required to permit members of the public to participate in the meetings. There was a challenge. Someone wanted, in the general audience, wanted to give input. The ZBA, for whatever reason, said, no, we're not taking it. There was a complaint lodged. The Attorney General said, you don't have to do that. You, even as a quasi-judicial board where you're having a hearing, the board gets to decide what they want to hear. You hear from the applicant. The applicant is supposed to make their case. If you want to hear from opposition and so forth, you can do that, but there is no requirement. It's not my constitutional right, free speech and all that kind of stuff. If you ever hear a phrase that's used improperly is First Amendment, free speech, I'm entitled to do this, that, or the other. Well, no, because, you know, time, place, and manner, if you're having a hearing and so forth, there are rules, and we all follow the rules. All right. What about recording, video recording, audio recording? Under the new open meeting law, the chair has to make it's assumed that this can be allowed with appropriate restrictions, but the chair has to make a declaration that the audio or video recording is happening. This is a sort of a nod to the wiretap statute that, you know, people can't be recorded without knowing it. And so anyone who wants to record has to tell the chair, has to let the chair make the announcement, and the chair can reasonably regulate the goings-on. All right, I was at a meeting in my neighborhood about something, the hospital that's across the street. It was this issue about expansion or whatever. It doesn't make any difference what it was. I got up to speak. There was a person there who had a video camera who was going around making a videotape. That person was sitting in the row, sat herself in the row right next to me, turned and put the video camera right up in my face. I didn't care for that. And I took my notes and I held them up. However, the chair can monitor that kind of stuff. The chair can say, as the courts, they do in the courts, if you're going to take, you're going to be in one place. That's a very common rule. No roving going on because it's disruptive. And, you know, various other rules that might be appropriate given the situation. So, all right. So now let's talk about executive session. This is a biggie. There has been some changes in executive session. One of the changes, this is a card that we put together having to do with executive session because it is a bugaboo. It causes a lot of problems. It's a basis for a lot of complaints. This will be up on the town's website. What they did, you might have seen our old ones. What they did is they went and they monkeyed around with the numbers. God knows why, but they did. So certain things that used to be separate before are now bunched together and so forth. So if you're a person that likes to cite things by the numbers, well, the numbers have changed. That's not a good idea. You shouldn't say, I'm taking a vote to go into executive session for exemption number 3. That is not good. You want to read what the exemption is, because exemption number 3 happens to have 2 different things. Now, this is a good example of one that was blended. It used to be 2 separate ones. One to discuss strategy with, in connection with collective bargaining used to be one, and another was strategy in connection with litigation. They put the 2 of them together. What's in common is that the chair has to declare that an open discussion would have a detrimental effect on the town's position. So they have that in common. However, it's a different day now the way these are set up. Also, in one respect, it's become more liberal. You didn't used to be able to, number 2, to conduct a strategy session in preparation for negotiations with non-union personnel. The old one was written union or non-union, but now it says to actually conduct the collective bargaining sessions or contract negotiations with non-union personnel. It's liberalized it somewhat. So you really have to know what these are. So board members should have a copy of this in your materials that you bring to the meeting. Don't assume you know what it means. A lot of it's the same, but some of it is different. For one thing, nobody gets to start voting on an executive session, to go into executive session. No one gets to vote until the chair has made the declarations that are required under some, but not all, of the items. Not all. It would be simple if you did it the same way for all of them, but it isn't for all of them. All right, so, oh yeah, okay, we'll talk about that in a second. Before going into executive session, so the chair must state the purpose and state all subjects that may be revealed without impairing the town's position. This is new. You used to be able to say, for example, we are going into executive session to discuss strategy in connection with pending litigation. You can't do that anymore. You are required to state the litigation unless that statement itself would impair your litigation strategy. It might impair your litigation strategy if the discussion is whether or not to sue someone. But if it's ongoing litigation, you can state that we're going to discuss strategy in connection with this ongoing piece of litigation. The AG will not cut you, slack on that. So you have to be careful about whether you are actually stating as much information as you can. This is an important difference in terms of going into executive session. So the Attorney General has ruled that the name of the case in litigation must be disclosed. You still have to do the vote to go into executive session by roll call. It's a majority, but you still have to go in by roll call, come out by roll call. All votes in executive session are by roll call. Same as before, you also have to reveal whether you will be coming out of executive session into open session. In other words, are you going to recess the whole meeting when you close the executive session, or are you coming back out? You often have members of the press, of the media there who, among others, want to know, is there going to be more, you're going to come out, you're going to make any announcements? Just because you are talking about a matter in executive session does not mean that you will not necessarily announce what you did when you come out of executive session. Think about this. Discussion of strategy is advantages, disadvantages, how shall we proceed? It isn't a necessary thing that once you decide that, you're not going to announce it. You might want to announce you're going to sue somebody. You might want to announce that you're going to purchase some piece of land. So, the current law wants as much as that has happened in executive session as can be revealed to be revealed. Immediately thereafter, if it can be. Now, executive session minutes, a big problem. Executive session minutes have the same protection as the executive session, as long as that executive session purpose is served. There has been a debate going on about whether when you settle with someone, whether the fact of that settlement can be kept confidential, and it depends. If the settlement is filed in court, it will become public record. Therefore, you have to be very careful about taking the position that the executive session, in which you discuss that settlement, the strategy in connection with the settlement, that is no longer, if you take the position that that is still protected. So let's say you got something in the mail about a piece of litigation, let's just say. It proposed a settlement. The board takes that into executive session to discuss the strategy in connection with that. Shall we or shall we not? Shall we counter-propose or whatever? If they decide that they are going to settle after having that strategic decision, they have to have that vote to settle it. The law wants them to do two different things. They want them to announce that vote out in public record as soon as possible, and also to replicate any part of that deliberation that can be stated in the public session. Once you've had the back and forth and the nitty-gritty about, well, I don't know, and this, that, and the other, some of that we'll probably want to keep in executive session. But executive session minutes are supposed to be frequently reviewed The Attorney General is not too understanding about the fact that you have executive session minutes that have piled up for years. And I understand that that is a big problem, especially if you have some that have piled up. It takes a while to go through them. But more and more we're seeing pressure. This is not just in Winthrop I'm talking about. Believe me, this is everywhere. We're seeing pressure to disclose those executive session minutes. It is possible to do this legal term, redact. You've heard this term, redact, big black pen. You cross out things that have to remain private. The Attorney General is looking to review these executive session minutes. The Attorney General wants to see them confidentially and wants to see them without any redaction. And then if it's appealed to the Attorney General, there's a decision. Can all or some of that go out to the public? So there's a really close scrutiny going on that at this point. So the Attorney General found that the Amherst Cullen Regional School District violated the law by stating that it was entering the executive session for contract negotiations when it actually received only an update. Strategy in connection with something is not the same as getting a status update. The AG stressed that the precise reason for entering executive session must be stated and that such action was not a mere technical violation. He's serious. When I say he, it's the assistant AG. All right, so here's some practicalities. You have to give the name of people who are involved. You have to give the name of the litigation as much as you can. In West Newbury, the selectmen met in executive session to receive and discuss written communications from town council that listed legal matters on the meeting notice. The AG found this violated the law and at a minimum needed to specifically cite strategy with respect to litigation. So if I send something to the town that says confidential litigation strategy, the agenda item should say to discuss confidential litigation strategy in connection with communications from the town's attorney. All right, so now we have many exemptions. How are we doing on the time here? We're coming up to the time, aren't we?
15 minutes.
Yeah, we're coming up to the time.
Good fight.
All right. So much to cover.
Time if you want to leave a couple of minutes for questions.
Yep. Let's skip over the executive session purposes because you can read those, and I've already given you some stuff on it. Let's talk about enforcement. This is new. This division of open government did not exist before. Now, a member of the public can file a complaint. The complaint doesn't get filed with the Attorney General. The complaint gets filed with the town. And there is a system that is set out in this information I've given you where there's a back and forth. And it has some kind of tight timelines, but they can be varied a little bit. Okay, the person who complains has to file a complaint within 30 days. This is all going to be in the documents that's on the website, so you don't have to worry about that. Has to be within 30 days of the alleged violation, but like many deadlines, it's when 30 days from when it happened or when they became aware of it if it wasn't public. So, you know, if the idea is something about secrecy and you didn't know, the person who complained didn't know, well, they can make an argument saying, well, I found out on a certain date, and so I have 30 days for them to complain. But they should do it promptly. Then, the public body is supposed to forward the complaint to the AG. AG does nothing about it, just sits there because the AG wants the town to work it out. There's a time period of 14 days where there's supposed to be some communication back and forth, where the public body gives the complainant whatever information they can or says, we can't give this to you because it is not public information. So you can get an extension, but the complainant is required to then file with the Attorney General within 30 days. So there are all these little deadlines that are probably easier for you to read than for me to tell you. But this complaint has to be made an agenda item at some meeting. If you get a complaint, it is necessary that that be put on the agenda. We put that on the agenda for a discussion. And it has to be a discussion in open meeting. And so you have to acknowledge the receipt of the complaint, you have to deliberate about the complaint, and the board is expected to try to quote-unquote resolve the complaint. How they resolve it will depend on the nature of the complaint. And if it's appropriate, then the town sends something to the Attorney General. The Attorney General reviews this. The Attorney General has options to either do an informal resolution, which might be a letter back saying, oh, I got this, and, like some of these things I read to you where the Attorney General says there was no technical violation, but we really should do something about it. But the Attorney General can take more formal enforcement action, can issue an order that tells you to do certain things. An order can tell you even to reinstate an official, someone who was, terminated. The order could do such things as to nullify the vote that you had in executive session. So there is a full range from very, very lightweight to very, very serious. And often the Attorney General is part of this, no matter what the Attorney General does, will say, we want you to cure this by having public disclosure, by stating in public what happened, by republishing, renoticing, and those sorts of things. So there's a wide variety of how that can be handled. So, for example, the Attorney General determined that the Milford School Committee could cure a violation which had to do with a quorum deliberated outside the meeting by raising the issue of the open meeting violation at the next meeting, explaining the nature of the violation in open session, recommending that the committee reconsider its motion and vote again at another date. So it's a redo. All right. So I think that basically talks about what you need to know about enforcement by the Attorney General. The Attorney Generals, the town can, if they don't like the decision of the Attorney General, there is a way to appeal it in court. However, oftentimes the easiest thing to do is to just fix it. There may be times when the town's really going to have to say, no, we really can't let this information out. One of the time-honored things and the most protected is personal information about mental health, physical health is treated very, very protectively. And so there may be times when you just have to draw the line. Now, at the end of this presentation, what I have here is the websites where you can get all this information restated by the Attorney General and read to your heart's content. And I'm sure that you all want to spend a great deal of time on these websites. So that basically is what I intended to cover, more or less. And so, time for questions.
We'll take questions first from the committee chair people, and then from the council, and then if there's time, we'll take it from the public. If not, we'll take it with public comment later on in the meeting. Ms. Osborne?
Hi, Ms. Lane, thank you for your presentation. I had a question about the posting of the notices. At the beginning of your presentation, you talked about the fact that we now have the availability of posting notices on a website. Does that have equal weight to the posting on the bulletin board?
The Attorney General is always looking for the most as possible. It does have the equal weight, but you will see that the Attorney General is saying, do this and do that. Do this and do that. Let me see if I can read you where that is. So it's right in the statute, for example. Let me see if I can find it. I don't know if I can put my hand on it, but when this whole thing came up about doing the website, what the Attorney General said, yeah, you can do that, but do more than that. You can always do more than that. If you are one of the few places in the world that can't put a notice outside your building, then put your notice inside the building, and a lot of times they were putting them inside the window. So it's not an either or. You're being encouraged to do more and more, and that's what I'm seeing everywhere. That's what towns do. They do it the old way, plus they do it as much of the new way as they can.
Is there any other committee chairperson or designee? Yes, Linda.
Hi, thank you.
Just identify your name and your committee, please.
Sorry, Linda Broussard, I'm the chairperson for the Parks Committee. So I have a question. So basically the Parks Committee needs to discuss playground upgrades, fundraising, things like that. And in a couple of our meetings, we always invite public comment. And in a couple of our meetings, there's been public comment they're outside the realm of playgrounds. It has to do with parks, but not specifically with playgrounds. And what we've done is redirect them to the town council to discuss their concerns about whatever it is. Is that appropriate?
That's fine. The problem is not getting drawn into a debate. because if someone doesn't understand what you're saying, they're gonna want it back and forth with you. You just have to say, we can't go there because it's not on our agenda. You just have to say, we cannot discuss things not on the agenda. But here's a piece of information for you, the proper forum is with the council. End of discussion, next, and move right on. The board members get into trouble by trying to be nice, but that doesn't really get you anywhere. Because you can never be nice enough to satisfy everybody, number one. And number two, being nice gets you into areas where it's not really within that box of your jurisdiction. So,
Any other chairpersons or designees? Chief?
Just on the 48-hour rule, you said they no longer consider Saturdays. Saturdays were the new addition. What's the intent behind that? Like, the intent is they assume everyone's open on Friday, or when Winthrop are closed on Friday, so it's 48 hours of actually being open.
well, it depends. Let's take Winthrop, and you're not the only town that's closed on Fridays, but it has to be accessible all the time. Because town hall is closed does not mean that there aren't notices posted in a way that you can read. As I said, sometimes you just put them on the inside of the window. I can't speak to the intention of the people who drafted it because it was not I don't necessarily agree with everything. The problem is, if the law is you can't go over 55, if you get stopped over that, you can't get into a debate about whether it's a good idea or not. You're just going to do it. But I think that what seems to be the case is they feel that Saturdays aren't good days for notices because people don't go to town hall that much. That might not be true. I mean, in some towns, the way they have things organized, there's a lot of activity in town halls, but they have one rule for everybody.
Thank you.
Any other committee chairpersons or designees? Just identify
Yes,
anything.
School committee. If members wish to attend an agenda meeting, can't you post the agenda meeting as a public meeting?
When you say agenda meeting, you mean a
You're
meeting?
going to set the agenda for the next school committee meeting.
Yes, that is a
If
public
members
meeting.
wish to attend, couldn't you just make that agenda meeting a public meeting by posting it 48 hours?
Definitely. And that's what you should do, because it's a topic for deliberation. If it's just a matter of who can be there that night, that's not something to deliberate with, yes or no, I can or I can't. But if you're going to get into, I think it's a really bad idea that we always do it on Thursday, that's a deliberation.
Tony, your name and committee, please.
Chair of the Noise, Air Pollution, and Airport Hazards Committee. Who's responsible for physically putting that up on the 24/7 hard copy? Is that the town clerk or?
It's really the duty of the board to make sure it gets done. You can use the services of the town clerk, but the law doesn't say the town clerk has to do this. The town law says the board has to do it.
So if it's locked up, then you need a key to put it up?
You have to make an arrangement so that that can be done. You have to get somebody on the inside that can help you with that. You have to get the materials to that person in advance for them to do the posting. It's planning. There's a lot more planning that has to be done now to comply with the law.
Okay, one other thing, please. When I send out an agenda to the town clerk, I also include the other members of the committee if it's going to them. Is that something I should be doing or just send it directly to them?
Are you saying you give the town clerk the materials that you also give the board members? The town clerk doesn't need those materials. If you like the packet
Like
that
the
goes to
agenda
the...
that's going to be posted on the board, on the electronic board.
He's just saying the agenda.
The agenda, yes, yes.
So I can include everybody in my committee and I include President Gill.
That's fine, that's fine. You can give information. You can send out information, you can send out materials, you can send out reports. You just can't have a discussion of it.
And that's publicly and privately.
Well, when you say private, what do you,
Say like some concerned citizen.
that you're sending materials to
I'm
some...
also including him in the distribution of.
That's tricky, that is tricky, because that example that I gave where the committee chair had created a listserv, see, if you give some concerned citizen and not someone else, that can lead to allegations of unfair treatment, you're in the inside group, that type of thing. Yeah. So if it's posted on the website, which is what's so great about the website now, it's all there, you just say, go read it. You can put it, I don't want to speak for how you run your web, but I mean, there's all kinds of things that you can put up there.
Committee chairperson or designee?
Can I ask a follow-up on that one?
Okay, then we'll come.
Would it be possible for the chair, would it be appropriate for the chair if there were people he knew that may be interested in, to separately email them the agenda?
Not a good idea.
Okay.
Because, see, that looks like you're playing favorites. But what some towns do is they have a little special area on the site for notices. In fact, Winthrop, for example, has that bulletin board function where, you know, I get notices about various things, so you send it out that way and say to people, everybody can find it there. As long as everybody gets it, it's fine.
Judy? Just identify name and your committee.
Judy Ball with the Historic Commission. Can you post an upcoming meeting without posting the agenda at the same time?
Not really, because it doesn't count unless you have the agenda. It's got to have the agenda. Otherwise, you can't do anything when you get there. It's only a proper notice if it has time, place, and all the topics with as much specificity as you can manage.
Any other committee people? Steve?
Steve Wachowski, Conservation Committee. We usually have a couple meetings a month, let's say. One is a hearing meeting, which I understand how we do it. Another one is a work meeting. Being specific, we would be covering, I guess, deliberation on specific items that we have to take care of. We could not just say a work meeting. We'd have to say, let's say, whatever the items are that we're going to have in the work meeting.
That's the safest way to do it. There is some ambiguous language in the new law that says that you don't have, it's not a public meeting when you, it's the language, something like decide, it uses really bad language on a decision. I would not try to use that. I would be as specific as I can. I would list, you know, here are the outstanding matters that we have reached. If you never reach them, it's okay. It's all right to put things on there you never get to, because if you have it on the agenda, you're not obligated to do it.
Okay.
If you don't have it on there. But see, when you are writing up that decision, again, here's a good example, no public input. Nobody can argue that you closed your decision. Even, you know, you didn't even have to let people argue to you when you were trying to formulate your decision. But after that, no more input, right? Because you can't reopen
Well,
the
that
hearing.
was the follow-up question I had. Is we have a hearing, get all the information, we close the hearing, and then we have our work meeting, deliberation, or whatever you're going to call it. We do not have to accept any input from the public.
You can't. You can't.
That's what I'm saying.
You
They
can't.
can be there, and then, because
The
it's a
curtain
public
has come
meeting,
down.
the public meeting is there, they can see us deliberating, but they can't have.
And I would be very, very, and if people say, oh, question,
I know,
don't
I
go
understand.
there.
No, I
Don't go
understand.
there because, yeah.
Okay, the meeting was scheduled to end at 8:30. However, we lost about 10 minutes between some technical difficulties, so I'm going to, if there's no objection, add 10 minutes on to make up for that. Mr. Massaro, just which committee you're representing?
John Massaro represent, I sit on, I don't sit on the school committee, but I'm there. And I'm also on the school building assistance committee though. But my question goes back to new business. There has to be an agenda, on the agenda under new business. If there's nothing under it, then you can't take new business. Or if somebody brings up new business, then that has to be scheduled for another time.
You know what? New business is an obsolete term. It doesn't work anymore. Sure, if you want to use it, but you still have to have every item. There's no more catch-all. Right?
So should you even have new business on the agenda as an item?
It's up to you, but if it doesn't have underneath it 1, 2, 3, then it's meaningless. So, you know, as I say, it's really obsolete. So if you get rid of it, it's only your own management issue about what order you want to take things in. Do you want to do new business before old business or vice versa? You know, that type of thing. But it's not a legal requirement.
Any committee chairperson who has not yet been heard from? Who has not yet been heard? We're going to come to the council in a second. Mary Lou?
Mary Lou Osborne from the School Building Committee. I apologize, I didn't introduce myself before. I had 2 questions. One is, what is our obligation about notifying about cancellation of anything?
That's practically speaking. It's more of a practical problem than a legal problem. You know, you use every method that you have, you know, such as, you know, we have the meeting calendar, and, you know, I've seen it, and this is very common every place. You hover over it, or you click on it, and it tells you what's going on. You can put something there, cancel, you know, change the message. That's a matter of courtesy, you know, because you don't want people coming for nothing. But the law doesn't really deal with that.
Mr.
And my other question was related to a board that has subcommittees. If somebody who's not a member of the subcommittee, but is a member of the full board, attends a subcommittee meeting, I think you mentioned that that person could be there as an observer. Are they allowed
Okay.
to speak or
All
ask
right.
questions?
I'm glad you raised that, because let me just tell you, you know about executive session? When you have an executive session to discuss litigation strategy or whatever, you cannot ever have the other side there. You know, you can't use that to negotiate over the purchase of the property or to negotiate with the other side in litigation about whether you're going to settle it. You're strategizing amongst yourself. This is something like that, because in an executive session, you can have the town planner, you can have the friendly advisors in there. Similarly with theoretically, with this subcommittee, if everybody agrees that another member can be there, yeah, but you can muddy the water because, let's say the subcommittee, let's say there's 3 of them, they were going to vote on something. Now if you've got a member from the full committee, you've muddied the waters because you had a subcommittee for a reason, which was to minimize the number of people involved, to make it more efficient, and so forth. So I don't think it's a good idea.
Okay, thank you. Gary, you had one more, did you?
The school committee has an ending item which is called public relations, in which school committee members can say pretty much whatever they want. There's a fundraising dance at the Elks, or there's a march going on over here. It wouldn't necessarily have anything to do with the school department. These items are not listed on the agenda.
Okay, the rule is no deliberation, so it's an announcement. Public relations is kind of fancy, but it's basically an announcement, is it not? An announcement is, here's the information, okay, next. So if you do it that way, that's fine.
Any members of the council?
Well, I would have to.
Yeah.
We have the same question.
Yeah, that's, thank you. We were thinking about, the challenge that we have in terms of the chair acting in a capacity to consider things not on an agenda. It used to be the case where a chair could have discretion as to whether to take up a matter or not. Are you saying that that discretion is no longer available to a chair?
I am saying the discretion must be exercised at the time the agenda is put together. That's where the discretion is. What's going to go on the agenda?
So something at a meeting occurs, or subject matter comes up. The discretion, the chair no longer has discretion to ask for the deliberation of the council.
Only if it's an
on that
emergency or urgent deliberation. Somebody says, hey, you guys, you don't know this, but we really got a problem, whatever it is, We've just been defunded or something like that, something you need to know that's really urgent. You can take some information, but the extent to which you could deliberate about that is the extent to which that is a real emergency or urgent. If it's not an emergency, very urgent, you say, thank you for that, we'll put it on the next meeting. And the chair can actually say, I'm putting it on the next agenda. But this reasonably anticipated that I mentioned, if you could have reasonably anticipated it, obviously you can't go there. If it's a true emergency, you can have any discussion you want, but you have to declare it's an emergency and you have to be ready to defend that. And then this is gray area in between. But as I say, the chair has substantial discretion when setting up the agenda. That's why it's very important that information go to the chair, because it's the chair who's going to make a decision. And you can debate it later, but you can't debate it before the agenda gets set. There is no lawful mechanism anymore to do that.
Thank you. Any further from the council? If not, Mr. Osborne.
Ms. Lane, you explained the complaint process and what's required of a public body. I have 4 complaints with the Attorney General of the Town Council that are on record now. I have one in the school committee and another one to come up within a week. So there'll be 6 complaints. This is over a period of about 60 days. Your advice, legal advice for the council, based on what you presented to us, is how a public body is legally supposed to respond to the law. You have, if you are representing the town, which you are in these cases, you have not provided any response in the 14 days.
Okay, I have to stop you there. No, I have to stop you there because we are also restricted by the agenda item that we have here, which is
It's
training.
a question about the open meeting law.
Well, it's not about who did what when.
No, I am asking for you to give me the advice as to why this
You-
public body
you
is
just-
not.
you just went outside the agenda.
No,
I cannot give individuals advice here. All I can do is
No, I
give
don't
general
want
training.
advice. You have given advice on a complaint
I
process.
think, Mr. Osborne,
The town council is not going along with the.
I know you don't agree with
of
me.
the law.
I know you don't agree with me. I'm saying we're
Mr.
outside the agenda.
Mr.
We're outside the agenda of
Osborne,
the
the
open meeting
purpose
law.
the purpose of tonight is for a seminar to discuss the open meeting law, not to discuss individual cases and individual questions.
I've identified generically cases. not
Tonight, the
individual
purpose
cases.
of tonight is to discuss the open meeting law, not individual complaints, which you spoke of. You have five complaints with another one pending.
Yeah.
The purpose of this meeting tonight is not to discuss those cases. The purpose of this meeting tonight is to discuss the laws. Your question is out of order.
All right, my point is, I've been given advice on the open meeting law by our council. My question is why the town council is not abiding by the law.
Your question is out of order.
It's out of order.
Yes. Any further
We
question
don't
from
need
the...
an open meeting violation tonight. That would really be unfortunate, wouldn't it?
Yes, it certainly would. Any further questions from the audience, from the public, regarding the open meeting law? If not, thank you all for attending. Thank you, Betsy, for running the session. And Mike, would you this is all going to be on CAT, and when you get the PowerPoint, did you say you were going to wind that in?
Tomorrow.
Okay. Thank you all for attending. We're going to continue on for our meeting, but if the council, I would accept a motion for a 10-minute adjournment, 10-minute recess. Okay. 5-minute recess. Call the meeting back to order. If I could ask, please, for a moment of silence, please rise for a moment of silence. One of our beloved school teachers, Bill Hurley, passed away yesterday, or the day before. And Bill was with us in our school system as a math teacher and the department chairman for many years. So if we could just have a moment of silence in Bill's memory. Thank you. To return to the agenda, the minutes for September 2nd as circulated. Could I have a motion? Motion by Vice President Del Vento, seconded by
I'll second that.
Councilor Barone. Any discussion on the motion? If not, all those in favor say aye.
Aye.
Opposed? It's unanimous. Next item on the agenda, Mr. Massiro wanted to give us an update on the opening of school during the transition process.
Thank you, Mr. President, to the council. First of all, I just want to tell you that we're up and running. We're in week 3, believe it or not. I am very proud of the Winthrop Public School System and the town of Winthrop. I think that we work very hard in partnerships between the Department of Public Works, the school custodians, all the different departments that work together to handle this transition that we were given the task of by eliminating a building over the summer and putting 12 grades into 3 schools. The issues that we are having currently right now are your typical issues that you have at the beginning of school years, with scheduling issues or trying to make sure that we work out all different types of logistics. So I do want to tell everybody that I am very appreciative of the hard work that everybody has done over the summer, as well as we are now working within the school year. So we are moving, we are making sure that these transitions have been smooth and seamless for our students. I'll tell you, our students, I believe, they can handle anything, and they are, we talked to them last week at the school committee. School committee members asked them questions, and they were, very open to what was going on and felt very good about the school year as it runs. So as we move towards the years now, we're going to put the transition behind us, We have a high school, we have the Cummings School, which is our intermediate school, and we have the William P. Gorman Fort Bank School, which is our lower elementary. And those are our schools, and that's where we're going for the next 2 years until we move into the transition of the new Winthrop Middle High School. In regards to the transition, if anybody has any questions, I'd be happy to answer anything on that. As far as the school itself, the high school project, we are moving right on task. They just completed the demolition component this week, and now we're getting into the piers and all of that talk, that construction talk, that for those who understand it, know it, and for us layman terms, we're basically getting ready to get the foundation in by December. So that's the basis. So we are on task, and we're moving forward on that area.
Thank you. Did you want to mention something about the endowment? And the
Yes. So what I would like to inform you all is that, and you may have read it in the paper or seen the school committee, Paul and Norma Fasella, who are graduates of Winthrop Public Schools. Paul grew up on Shirley Street. I had the pleasure of meeting Paul 3 years ago. Paul and Norma Fasella had been giving a $5,000 scholarship to the Winthrop Public Schools for a student or 2 students. They would sometimes split it up. They allowed the town scholarship committee to award that scholarship. And when I met with Paul 2 years ago, Paul, his wife had passed away the year before that I had met Paul. And Paul decided that upon his death, he wanted to give an endowment to Winthrop Public Schools for scholarship purposes. And so that students from Winthrop could always have an opportunity to get, advance and have a little better shot than other students from other towns. Is quite frankly what he said, because he's always been proud of being from Winthrop, and he loves Winthrop, and Winthrop gave him opportunity. So currently, right now, we're waiting for the final things to get worked out. And I did meet with the accountant and his nephew. And so where we're at this point is that we're looking at an endowment that's about $6.5 million with an interest rate probably anywhere into the 300,000s. And what the job of the town scholarship committee is, and the requirement of that, is that we have to spend every penny every year of that interest on scholarships, with the exception of 2 other areas that have a percentage written in on that. One going to advanced placement testing, and the other going to athletic equipment. So I mean, when I heard that news from them, I actually stopped for a second and just, tears swelled in my eyes, because this is a huge, momentous gift for our students in our community. And I want to thank the scholarship committee. I especially want to give big, great thanks to Gail Conley, Annette Bettino, and Rona Mayo, who were part of that, who were very instrumental in the beginning stages of working and developing this with Mr. and Mrs. Fasella. So,
Thank you, John.
thank you.
I have a question.
Yes, sir.
Just one question.
Counsel.
Because now that the demolition is done and they're going to start building it, originally we had talked about, and I had tried to make a motion at one time, but we said that they were going to agree to do a job fair and hire some Winthrop workers for this project. And I don't know if that's happened. I'd like to know if that is still going to happen, and if you have had any communication with them through the
I do go to Tuesday morning construction meetings, so I will bring that up with them again to talk. I do know that what happens is everything comes in by bids, and right now they're finalizing the foundation bid, and then the next is the steel bids that come in. So I will communicate that again to Gilbane.
Yeah, because I thought they had at least made a verbal agreement that they were going to attempt to hire residents, so some of the money we're spending stays in town.
Right, correct.
Any further questions for John, or John, any further comments?
Thank you very much.
And high five to the football team last week.
Oh, yes.
Good job.
Very good. Thank you, John. Moving on, I would ask the council, we have some people here in the audience who have an issue, I guess kind of a misunderstood issue of what was going on with an item that was on the agenda and discussed at length at the last meeting. If the council has no objection, I'd like to suspend the agenda, move to old business, and deal with this issue so these people don't have to hang around, and we can sort of explain what took place at the last meeting. Were any of you here at the last meeting when the discussion on this took place? No. Okay.
Motion to suspend.
Motion to suspend by Council Vice Barone, seconded by
Second.
Council Vice President Del Vento. And we'll move on to old business, to the item of...
I'll go to vote.
Time for a vote, yes? All those in favor of suspending the rule, say aye.
Aye.
Opposed?
None.
Council Boncory never likes to suspend the rule. That's not a personal issue. He just believes in staying with the rules. Just to backdate a little bit what happened, I'm going to read a letter from Rich Boyajian. Rich was the one who proposed the motion that I don't have the motion in front of me, but in effect, it talked about looking into having the set. You got it? Okay, thank you. Rich's motion was that... Phil, light this up.
Yeah, I got it too.
I move that the town council encourage the MWRA to establish a citizens advisory committee to meet with such committee on a regular basis to discuss areas of concern, both positive and negative effects of the operations at Deer Island and the town of Winthrop, or take any other action there too. The discussion that took place at the meeting last week was we referred back to several months ago when we talked about communication with MWRA. Councilor Del Vento was very clear in that if we did have that kind of communication, it should not be a committee of the council. We discussed very definitely at that meeting that it would not be a committee of the council. The members of that committee would not be chosen by the council. Then there was some discussion about there were some people already meeting with MWRA. And at that point, Mr. Del Vento asked that, not Mr. Del Vento, Mr. Lettieri asked that we postpone the deliberation of this issue until this next meeting. He is not here tonight. He's in California on an assignment for work. But he did ask to have me read this letter and clarify the issue. I'm sorry I could not be at tonight's meeting in person to explain my intentions as they relate to last meeting's motion to recommend the MWRA form a Citizens Advisory Committee. The intention was not to create a subcommittee of the council, or for the council to have any official role. My hope was that for the MWRA to develop and appoint private citizens to work with addressing any areas of concern. The impetus behind my idea was my concern that the more informal meetings had not met the needs of our community activists in the past. This was based on public comments that I heard earlier in the year. I was hoping the creation of a more formal committee would allow them to have a regular voice in the matters they care so deeply about. This informal arrangement is what our community, if this informal arrangement is what our community would prefer, I would be happy to withdraw my motion at the next meeting. I had no nefarious intention behind this motion. My only desire was to ensure our citizens had a seat at the table to voice their concerns. Subsequent to the last meeting, and specifically yesterday, Sunday, I did hear from a citizen, and I have talked to MWRA rep, who has assured me that there has been contact. There has been people representing the community. There is no formal committee, but there is communication going on. That was the intent of Rich's motion, to make sure that that was going on. He is willing to withdraw his motion, but he can't legally withdraw his motion because he's not here.
So say we move the question out of the motion.
I think then we could, Councilor Boncory is making a suggestion that we move the question. All those in favor of moving the question, say aye.
Aye.
Aye. All those opposed to moving the question, say aye. Say nay.
Yeah.
So it's,
Yes.
so the question is now moved. So now we will move to a vote on the question. In other words, the question that's in front of us is the motion that I just read, that the town council will encourage the MWRA and so forth away. Does anybody want me to read it again? Okay. All those in favor of the motion to encourage the MWRA to do what we said, say aye.
Aye.
All those opposed to encouraging the MWRA to do that, say aye. Aye. The motion does not, the motion fails, and therefore, that's the end of it. The citizens take over and carry on the way you did. You know what I'll do? What I'll do now is to cover the bases technically. I'll move on to public comment. So I'll revert back to public comment. And then I gotta, go ahead. Mrs. Manning?
Thank you. Okay, so, just so we're clear. Don Manning, Precinct 3. Okay, so just so I'm clear, so the citizens will have their own committee if they choose so. The council will not get involved in creating a committee appointed by the council.
Correct.
Whose job is it to make sure that MWRA is doing what they're supposed to be doing?
The committee that has a self-appointed committee who has, the MWRA, I understand, has agreed to meet with you on a periodic basis? Is that right?
No, that's not what I'm asking.
Oh, okay.
I'm asking
I think that's what she's saying.
whose job, who's accountable to make sure the MWRA is following the rules and doing what they are supposed to be doing, following the rules and regulations. See, because even though we might have formed a committee, we're just citizens. We don't have titles, and we don't have laws, and we don't have rules. We're just citizens together because we care. We don't have anything that says they have to follow what we say, but see, you have titles, and you have jobs, and you have paychecks that are supposed to make sure that they do follow the rules and the laws. That's what your job is. That's what I'm confused. I want somebody in the town to be accountable for them, to make sure that they step up and they do. So when I look at the agenda tonight and I see that there is an MWRA advisory board committee, I am confused by this because I don't know that we have one in town. I understand that Fire Chief is on it, right? We have somebody down there representing our interests, but who's really representing our interests? Like, yeah, he's doing it for the town because that's his job, but who's really doing that job? Because nobody's sitting up in front of my house. I sent you all that picture of the 52-foot truck going by at 8 o'clock in the morning.
I guess given the
Whose job
instruction,
is it?
I guess given the instruction that we just got on the open meeting law,
I understand, I do.
that we'll put that on a future agenda.
So I
But
guess.
as far as enforcement, if there is something that's going on, then any citizen calls the police department or the fire department. But as far as whose responsibility is what, I'll put that on a future agenda.
That would be greatly appreciated.
But I just wanted to go back to the Citizens Advisory Committee. That was a misnomer, but it's gone anyway, so
Correct.
it's not going to happen.
So
Because we heard you as a group 5 months ago saying, no, we don't want the council to do it. No, we want to do it ourselves. And that's better, by the way.
And we want that,
Okay.
we do. But
you also, at any time, are welcome to come to the council and present your concerns.
and we love that, but we also know that we don't get a paycheck by the town to do that. That's not our job. We do it because we love our town, and we live there, and we love it, and we want everybody to be safe. but we don't get paid to do it. So with the mitigation coming up next year, I don't know if there's a committee and if it gets appointed and who appoints those people. And I don't know how that works and who's working on that. And knowing that we're not going to get done for casino, I would think that we'd be pushing them very hard and we'd be working on that mitigation
Okay,
money.
do me a favor, would
Really?
you write me a bunch of topics that you want covered, for example, the ones you just mentioned? So that we just learned about the open meeting law, I have to be specific.
Absolutely.
And I'll put it on a future agenda, and we'll
I would
We'll discuss
absolutely, totally appreciate that.
yes, Counsel.
I think what Dawn probably is trying to say in a roundabout way is not so much, Dawn, who is personally responsible, but who's the go-to person when you have an issue.
Right.
And the council here is, what the council president is saying is that you come to the council, let us know what's on your mind or what you want to discuss. We put it on the agenda, we discuss it, we try to make a resolution for you. Is that kind of what you're, in the direction that you're going? Because it's not, nothing's in one person.
It sort of is, Mrs. Calla, but you know, when I send out an email to 17 people, when a fire truck goes by at 5 o'clock in the morning, not just one, but 7 from East Boston, because there's an electrical fire at 5 o'clock in the morning down Deer Island, 7 trucks booming with their lights, and I'm getting out of bed because I'm thinking, oh my God, Deer Island is blowing up. There's 7 trucks, and I'm running outside to see if there's a hazmat unit, because why else is there 7 trucks going down at 5 o'clock in the morning? Because I didn't see Winthrop, and I know Winthrop doesn't have hazmat suits, so why is Winthrop not down there? Because Winthrop doesn't have hazmat suits, so it must be something hazmat. So 7 trucks at 5 o'clock in the morning. I just want to know who gets that call. Like, we don't have an evacuation plan. I want to know, not the council. The emails go out and, yeah, okay, get a couple back. But we've never just gotten an answer. Who's going to step up and say, I'm going to be that responsible person because I get a paycheck. I'm the boss. I'm the leader. I'm going to get that answer. I'm going to be the one that says, I'm going to have an evacuation plan for you.
Okay, thanks, Dawn.
You're welcome.
Just write me up that little email.
I'll get you that whole
Okay.
list.
Thank you. Any further public comment? None, seeing none. We do have a public hearing scheduled for tonight, and it's in regards to the town ordinance that refers to motor vehicle storage, and it was a motion by the Rules and Ordinance Committee to delete the town ordinance 17.12.080A, and it was to replace it with a new 17.12.080.A, storing of motor vehicle restrictions. And it reads, no person shall have, keep, or store more than one unregistered, uninsured, or inoperable motor vehicle, boat, trailer, camper, or recreational vehicle ungaraged on his or her premises for more than 72 hours. Nor shall any unregistered, uninsured, inoperable motor vehicle, boat, trailer, camper, or recreational vehicle be stored in front of the yard of a residential or commercial business, except lots duly licensed in accordance with Winthrop zoning ordinance 17.24.080 by the Winthrop Licensing Board to be used for outdoor automobile rental, sales, storage, or rental or sales. This came to committee, and last meeting was referred to the planning board for their review. Planning board met last night, talked about the issue. They also feel compelled to have a public hearing on the issue. Basically, what this does is it says that currently the law says exactly what this says, but refers only to residential. We want the wish of this change is that it will also refer to commercial places where unregistered, inoperable, uninsured vehicles are parked for extended periods of time. So, this being a public hearing on this issue, is there anybody that would like to speak in favor of the zoning ordinance? Anybody in the audience? If not, we'll close that portion of the public hearing. And is there anybody who would be wanting to speak in opposition to this ordinance?
I just want to have a question.
Pardon me? Yeah, I'm going to come to the council after the ordinance. If there's no one in the public, we'll refer it back to the council for comments. Ms. Council Cal.
In here it says,
should not be stored in the front yard of a residential.
I'm sorry?
It says it should not be stored in a front yard of a residential or commercial business.
Right.
What about people that have a big backyard and they want to store a boat that's not registered or not insured, but if they have a large backyard, it's not in the front, no one can see it, it's not
Right, the
visible?
first sentence refers to that as long as it's no more than one.
No more than one, okay, that's good.
And that can be on their lot other than the front.
Okay, perfect, yeah.
Yes, Councilor?
That's one. Now, if you had two registered boats, it would violate.
No.
So I know that the planning board had an issue with it. Did we reflect that in the report?
Yes, I can. They did say that they were concerned about the 72 hours, and what if somebody had his car in a repair shop and it was inoperable, and the mechanic couldn't get to it within 72 hours, he had to order parts or something. And I'm sure that there would be flexibility on an inspector's part, if it was, they thought maybe it should be 7 days instead of 72.
Yeah, I just think that that's fair for everybody to know that there was.
Yes, oh, yeah.
That there was a discussion there last night because, the feeling was 72 hours, the car comes into a shop, damaged on Friday. Monday is pretty tight on 72 hours, they haven't done any work on it.
Well, unless we deal with the open meeting law, 72 hours would be Friday, Monday, Tuesday.
Well, geez, yeah, not as good as Wednesday. But I think that, the intent is to not also create a secondary issue. And I think that there was some feeling on the part of the licensing board that we were, a little aggressive on the 72 hours and maybe.
It was the planning board.
The planning board, I'm sorry. And maybe a week was a better term. The overall goal is to make sure that people aren't using it as a parking lot. It's not to impede their flow of business. So
Yeah, and they were, I won't say they didn't take a vote, but they seemed very supportive of the idea of not having junk cars stored on open lots for an extended period of time, and that's the goal.
I think that I think the intent, they were certainly comfortable
Right.
with. The application, I think there was a bit of a difference, and I personally would, make an amendment if you can you make an amendment now or not?
Not till it comes back. What'll happen is this motion will come back to us as a council to vote. Planning board will make suggestions, but it's up to the council to vote the motion, and when this motion right now it would be best to postpone it until we hear back from the planning board.
I wasn't
And then
under the impression that they were taking it up again. I thought they, maybe I missed it. It was a long night, so.
Yes, they
maybe
are going to discuss it again.
They're going to bring it up again and bring it back?
Yeah. Did anybody else have any comment on this? If not,
Yes, the fact that, having written it, 72 hours is what was in the law prior to us adding the commercial vehicles.
Right.
And anybody that has a commercial place of business that's working on a car, they usually have it inside when they're working on it. And
Yeah.
and
Or in the backyard.
in the backyard.
Yeah.
And you usually registered and insured because they just got hurt and they're being worked on. It's not the situation where they're junk cars.
I don't disagree with you. I think what happens, when you're dealing in if we were dealing in the city of Boston and there was, 3 million acres, it would be one thing. I think what happens in town is people have a tendency to think of, the individual situations where this applies. And I think they felt that 72 was a little bit tight on it, and extending it out was
and that
potentially better opportunity.
that determination will be the council's determination, and it can be made as an amendment when it comes up to vote. Yes, Council?
And the other thing about it was specific as to the front yard. If it's a fenced yard, if it's within the garage of the property, that's one thing. They can work mechanisms in order to secure and shield their area if they need to. If there is a situation where they're working on cars for 2 or 3 weeks, or something to that effect.
Okay, very good. There's no further comment. I'll close that public hearing. Move on to committee reports, Councilor Del Vento. Finance Committee, Councilor Del Vento.
Finance Committee met last night at 6:30 in the Harvey Hearing Room. Present were myself and Councilor Lettieri. Also present were President Gill, Councilor Mail, Town Manager McKenna, CFO Gordon, DPW Director Calla, and Dave Osborne. I read the motion in its entirety, which will come up later, so I'm going to beg to not have to read it again. It was relating to appropriating $2.8 million of financing for the replacement of aged water mains on Cottage Hill and Pico, in the Pico Park, Ave Park area. Steve Calla described the project in depth to us. There were comments made by Dave Osborne relative to utilizing other funding sources for the project, such as free cash or putting it on funding from the general fund. Town Manager McKenna made some statements as to the use of the enterprise funds in accounts, and to keep, one of the necessities of the project was to keep our system improvements, which have lagged for many years, on track. Councilor Terry would like to see the discussion as to possible alternative funding. Councilor Mail made statements relative to moving the project forward, but would like to do full work, including the sidewalks. And CFO Gordon described it's an interest-free borrowing, and the cost will be, to pay it back in 10 years will be, to pay it back will be $210,000 annually. Motion by Councilor Terry to move the question forward for consideration by the council, which passed unanimously, and the meeting was adjourned at 6:50.
Thank you. Town Manager's report.
I'll stand and address the council.
All right.
And not be down the end of the...
Take the mic in.
Good evening.
Good evening.
I have a short report tonight.
Good.
That's why you're standing.
Is that it? You done?
Just 3 quick items, and then I'll turn it over to Tim to give you an update, which I'm sure you're going to like. We are moving forward with repair of the barge at the landing. We are out to bid on that, and thanks to Joe Montalto and the Harbor Advisory Committee, it looks like there is a solution that we're following there, and we should be in receipt of bids in the next week or so, and have that project underway. It's important that we fix the barge and use funds from the reserve of the Harbor Waterways Fund to pay for that. We plan on having that taken apart, essentially, and removed and towed to a proper site, railways, to be fixed. It depends on who the bid winner will be, but it's likely to be within the vicinity of Boston, where that'll go and be restored.
East Boston?
No.
No.
Sorry?
I thought where it would go, did you say?
We're not sure.
In the region.
In the region.
I'm going to interject with one comment so people understand. This isn't just a repair, this is also a scheduled maintenance for the barge. So
Correct.
we do keep it from falling to disrepair and having to do long-term replacement of it.
That's right, that's right. We should get roughly another 7-8 years out of it by doing this repair. It'll be securing both the undercarriage and the surface of the barge. But it's important that we do it so that we, for safety reasons, obviously, and to keep the barge functioning for us. I am under the understanding that the MAPC will select an award, a bid to a contractor to move ahead with streetlight replacement. And as we discussed quite a while ago with the council, we, the town of Winthrop, are one of the lead applicants in that effort, and we hopefully will have a contract within the next couple of weeks to replace the town's streetlights with LED streetlights. So I'll bring an update to the council the next time in terms of who that will be and how that process will unfold. Since the council won't be meeting again until the first week in October, I thought it would be appropriate to let you know that the logistics and planning for the Fall Fest are well underway with a meeting held last Friday. I know Councilor Sanford was involved in that meeting. as well as our public safety officials, and I thought it was an excellent meeting. Thoroughly examined the logistics of the proposed festival at French Square on the 28th in the afternoon. There's a lot of thought has been brought to the table on this. A very limited number of tickets will be available, 600. A lot of security, a lot of fencing around the perimeter of the area will be in place, and I trust that the police chief and the fire chief have taken every step necessary to secure the area and to ensure appropriate use of the area, the cleanliness of the area as well, and safety of the patrons.
What's the time on that? Is it 4 to 7 or 1 to 4?
It's in the afternoon.
3 to 6?
4 to 7. 4 to 7.
4 to 7.
Okay.
On the 28th.
28, yes. Thank you.
And I'll turn it over to Tim to give you an update on our bond results for financing the school project.
So I just wanted to give you an update. We went out to bond our first long-term issuance for the school project, and it was $24 million, and the terms of the borrowing were 25 years, 3.35% interest rate, with a premium of $936,000. So the significance of that, the idea was to take advantage of low rates. That's why we went out long-term early in the project. Not for the full amount, but for a large chunk of it. If you remember a year ago when we were preparing for the vote and informing the public and trying to come up with, we needed to come up with some estimates of costs, we took a conservative approach, and we estimated the interest rates at the time to be 4.5%, which is what we thought maybe we would end up settling in on. So when we did those estimates, the 4.5% resulted in an annual debt service of just over 2.8 million. With the 3.35%, if we're able to maintain that for the second round, which would be a smaller round, the savings would be over $300,000 a year in debt service, $320,000. And that isn't coming to the town, that's directly to the taxpayer, because as you know, it's debt exclusion. So when you think about, I know we talked about the average tax bill and what the impact was, and we had a couple of ranges there, but most of them were in the ballpark of about $510, right? It would average out to be about $510, $520. If we're able to maintain the 3.35 in our second round, that will go down by about $60 a year. So it's a significant difference. And so that's the update. I put the monthly report in your Dropbox.
Thank you, Tim. Are you set, Mr. Manager? Very good. Old business.
Old business, we have a motion from the Finance Committee. It has been, a hearing has been held on it. And the motion reads that $2.8 million is appropriated for the purpose of financing the replacement of aged water mains and lead services in the Cottage Hill surrounding area and Pico Beach surrounding area, including all costs incidental or related thereto, that to meet this appropriation, the treasurer, with the approval of the town manager, is authorized to borrow $2.8 million and issue bonds or notes of the town under Chapter 44 of the general laws or any other enabling authority, that the treasurer, with the approval of the town manager, is authorized to borrow all or a portion of such money from the Mass Water Resources Authority, and in connection therewith to enter into a loan agreement or financial assistance agreement with the authority, and otherwise to contract with the authority with respect of such loan, and for any grant or aid available for the project or for the financing thereof, which grants and/or aid shall be expended for the project in addition to the amount appropriated and to be borrowed under this order, and the town manager is authorized to acquire by purchase, eminent domain, or otherwise such rights, titles, and easements as they may be necessary for such purpose, to abandon such rights, titles, and easements as are no longer required, to expend all funds available for the project, and to take any other action necessary or convenient to carry out the project.
Is that a motion?
Motion from committee.
The motion from committee, just as a technicality, was it for this or was it to send it to the council? Is there a technicality, so we would need a second if that was the motion?
It could be a technicality, so let's get a
Okay,
second.
so motion by Council Vice President Del Vento, do I have a second?
So moved.
Seconded by Council Varone. So what we need to do with this now is move it off. It has been come out of finance, and we will need to move it off to a public hearing. And my suggestion is that we schedule a public hearing for the next meeting, same night as the next meeting, which is October 7th. Can we go ahead and do that? And yeah, she knows to advertise. Yeah. Do we need a vote?
No.
No. Okay, storing motor vehicles, we already talked about. Mr. Manager, the Shirley Street poll petition, is that still on hold, or?
Unless Steve has any update on the poll petition, I know you had some discussions with him today.
I did. I met today with Mike Cordima from National Grid and Paul Donovan from Verizon. What I was told in that meeting was Verizon actually mistakenly made the petition. It's actually National Grid's poll. National Grid needs to make the petitions. I spoke to them about not wanting the pole on the public way on the sidewalk. They're going to bring back, Mike Cordima with National Grid is going to bring back to his superiors the option for an easement to purchase a permanent easement from the homeowner at that location. If that does not, if they decide that they don't want to purchase the easement, National Grid is going to contact the council. They want to make a presentation. He would want to make a presentation in front of you to explain at this point that what he feels is a real necessity to do the work where it is a hazard. But there is hope that it may be settled if he can get the okay to purchase the easement and the pole will stay where it is.
So is it all right, council action, then 3 weeks from now?
Yes.
Yeah, okay. Because it is a scary-looking situation down there.
Yes.
Okay. So we'll keep it on for, we'll keep it on the agenda for the next time. Okay? Is that right?
That's fine.
We talked about the MWRA Citizen Advisory. Trash ordinance compliance, I just wanted to comment on that. In the last water bill, the DPW town manager included a trash ordinance reminder. I have had a few phone calls on it. I don't know if other councilors have. And I've had mixed reactions on it. One of the phone calls is that the person thought that we were changing the ordinance, and it wasn't a change in the ordinance, it's just a reminder of what the ordinance was. Steve very well called it a friendly reminder. It was a reminder that when the trash goes out and how it's supposed to be packaged. I've had I've had more positive comments on my calls, I don't know about the rest of the council, than I have had negative. I just want to say that I have seen some compliance. Part of the reason behind this reminder was people were putting out their trash the day before, and they were putting them out, and people are still putting them out in plastic bags. I understand the reason that ordinance was passed was both for aesthetics as well as for public health. The town has become cleaner than anybody has ever seen it. I keep hearing that comment, thanks to Steve and his crew. And part of the reason for the trash thing was to have it that way, that it doesn't get put out early, doesn't get put out in plastic bags, doesn't look like a mess. People aren't overloading, putting out 12 bags and 12 containers when they're supposed to put out 3. And the other issue was rodent control. Other cities and towns are really cracking down on their rodent control. And, you know, my feeling is that if we have poor rodent control and one of our neighbors has good rodent control, the rodents are going to come to where the food is. So my comment is I wish that everybody would pay attention to that, and that's the rules, and we would like to see them upheld. Covered barrels, not plastic bags, out the same day. The same day starts at midnight. Hopefully people would wait until 6 or 7 in the morning. I know it creates some difficulty for some people, but that's the rule, and I think we should live by it or change it one way or the other. Councilors have any comment that they've heard?
one of the comments I heard is that people leaving early for work, they're leaving town at, 5 or 6 in the morning, and they don't have the ability to put their trash out at 7.
No, it doesn't have to be, it can be any time after midnight. The rule says same day. It's,
I understood, but I was just relating people's understanding of it,
good, thank you. Anybody else have any comment on that? Is there any? So again, I ask the public to be aware of that and look around as you drive around it, and it'll make you more aware as you see people, being more cautious to do that. Thank you. Under new business, we have a transfer motion. Motion from the, request from the town manager that the town council vote to approve the transfer of $20,000 from the town council reserve to the town attorney account for the purpose of funding specialized training and assistance relative to employee relations, or take any other action relative thereto. Do I have a motion?
Motion.
Motion by Vice President Del Vento?
Sent to committee.
Yeah. A second?
Refer it.
Can I just have a second on the motion?
Yeah.
Finance Committee.
The motion is to refer it to finance. Can I have a second for that?
Second.
Second by Council Sanford? Jim?
Discussion?
Yeah,
I just want to inform the entire council that we are going to conduct full training with all municipal employees who are not otherwise covered under this effort through my end. We negotiated an arrangement with our insurance company to come out and supplement for the rest of the town employees, so that they will receive the same training that we're intending to do under this as well, although this would be specialized training and other matters that we can assist.
yeah, great. That answers a concern that the council had last week, so very good.
You encouraged us to reach out, and we did, and there you go.
Thank you for that. Good job. Any further discussion on the motion to refer to finance? If not, all those in favor say aye.
Aye.
Opposed? It's unanimous. Thank you. According to the charter, we have our fall forum in the month of October. Last spring, we did the spring forum the same night as the council meeting, sort of like we did tonight, except we scheduled the council meeting for 6 and the forum for 7, with the understanding that if we didn't finish the council meeting, we could have the forum, and then continue the council meeting after. What's the feeling of the council? Would they like to do it on the 7th or the 21st? 7th. Time, so, all right, how many people would like to do it on the 7th, just sort of a straw vote? Pardon me?
I'm not going to be here the 21st.
Oh, I thought you were going to say not going to be here the 7th, so you wanted to do it that night. No. If there's no opposition, if there's nobody opposed to it, we'll schedule the fall forum for the 7th of October. Could be ready for that, Mr. McKenna? Okay. I would then, if Council Boncory wanted to suspend the rules and make the council meeting for 6 and the forum for 7, is that a motion, Councilor?
I do want to.
What's the feeling of the council? Do we want to move the meeting of the regular meeting to 6 and then the forum for 7, or do we want to just go with the forum at 7? I mean, the meeting at 7 and the forum at 8.
Yeah.
Meeting at 7.
Okay, meeting at 7, forum at
6.
7:45. 8 o'clock.
I'm thinking 8:30, but 8 o'clock. So the forum will be at 7, the meeting will be at 7, so we don't have to suspend the rules, and the forum will be at 8.
Why don't we do it earlier? I think that's too late for people.
Pardon me?
I think that's too late for people, don't you think?
What's your suggestion?
The 6 o'clock.
Whoa,
Start at
whoa.
6 o'clock
There was
is too
some
early.
council
Oh, you can't get there
work
from
out of
work.
town.
Oh, I see.
So if there's no objection, it doesn't take a vote, I will schedule the fall forum for 7 o'clock. No, we did it the other way around. The meeting at 7 o'clock, the forum at 8 o'clock on the 7th of October. That'll be on the next, will be on the next agenda. Okay? Any problems with that?
I don't know, what if you did the forum first at 7 so people can go home, and then we can have our meeting at 8?
The only problem with that is if the forum runs long, if we have the meeting first, and the meeting's not over, we can suspend the meeting, have the forum, and then come back to the meeting. Whereas the other way around, if we have the forum first and it runs long, we don't get to the meeting at the scheduled times.
Just a question.
Nope, good. Any other question? Not. Moving on to appointments. I don't have any appointments, however, I do have a need for some people. Actually, I need 2 people on the scholarship committee. We have, as Mr. Macero outlined earlier, we have some significant amount of money there. I do have one person who has expressed an interest, but I don't have an application yet. And I also, if anybody is interested in the tree committee, the tree committee has become a little bit inactive, and we would like to get that back up and running, or not have one or the other. But so, tree committee, scholarship committee, we're looking for volunteers to make an application. The application is on the website, and you can fill it out and send it to Carla Vitale, the town clerk, with a copy of me. A couple of things coming up. The planning board had a meeting scheduled for houseboats, and it was scheduled on the 23rd. It was on the 25th of September. Council Mail pointed out that that's a religious holiday, and could they change it? And they did. They changed it to the 23rd, which is a week from tonight. It's here. And what they're going to do, it's sort of a public forum to hear what people think about houseboats in Winthrop, and to get some ideas of what we should do about them in the future.
What time is that?
As Mr. McKenna mentioned, the Fall Fest is the 28th. On this Saturday, there's the Neil Shapiro Annual Walk. Neil was a teacher who died very young, and they have an annual walk there. Last week's walk was tremendous. There was a great showing down there on the island for that. And the Winthrop Walk to School Day, initiated by Dawn Sullivan, member of the school committee, is on October 8th. She would like to participate. Does anybody else have anything on upcoming events or other? Great.
I get some other stuff.
Okay.
First of all, I want to publicly thank Paul Levy from Woodside Hardware. He provided a generous donation and helped us plant out the rest of the landing. If you haven't had a chance to get down there, it's really all looking good. And also, I was down there the other day, and there was a gentleman sitting in one of the rocking chairs, and he was rocking away, and we got to talking. And his name is Rich Fattel. He lives in Winthrop. He's lived here for 8 or 10 years. He runs a small business, a software business, and he was sitting in the chair, and he happened to mention that he donated both of the rocking chairs that were down there, and I said, you know, what we really need is 2 more rocking chairs down there. So he offered to donate one if someone else would donate another one. So we got them from LL Bean, so if anybody has any interest in donating a chair down there, that'll give us 4 chairs down there, and it looks really nice. A lot of people go down there and sit. The harbor there is quite attractive when you're just sitting around there. It's very, very nice to see a lot of people down there. Then I had 2 things that sort of caught me. So when the town goes out and does something, and it's sort of a general discussion that maybe we should have, but I'll just throw it out there. When the town goes out and does something, and we have to, you know, provide a legal opinion for someone, do we charge that back to the individual? I mean, if we have to go out and bring, you know, like take for instance, when you're going out and you're doing your repossessions and stuff, all those bills go on to the property, and we eventually would get to get that money back. So isn't it fair that if, you know, we get things that people come on and we have to do these things and we have to do this, is it fair to go back and ask for compensation? If we were to have a lawsuit and a land issue or something like that that we would win, is it not right to go back to the individuals that created that and said there's a jeopardy to this? So I don't know how somebody wants to handle that discussion or not, but
Just to follow Betsy's lead, we can put that on the agenda
Well,
for a future minute.
you know,
But
I-
you may be able to get an answer from Tim or Jim as to what we do with that.
I'd like to have a discussion on it to see if it's fair to do that, because we get caught up in paying for stuff, and I don't necessarily know that some of these things are fair to the town. You know, somebody asked us to have a Freedom of Information Act. We have to take the time and effort to pull all the paperwork together. There's a charge, I know, for it, but if they don't pick it up, we don't charge for the time, and that's a fee. and the time should be included in it.
We do charge for the time.
I thought we charged for the copies.
No, time.
Time? All right. We'll make sure we get.
Any other comments before we move on? If not, public comment. Kathleen?
And I understand you guys, gentlemen, women, just had a seminar on open meetings, so I don't even know if I can say this or not. So if I can't, just tell me to be quiet. So
So you can say,
Kathleen Capuccio from 49 Walmart Ave, and I don't know the precinct, as bad as that is. Two, what I just wanted to just say was that, as I'm sure you're obviously all aware, the town of Winthrop in the Mass Water Mitigation Agreement is expiring in 9 months. The current MOU, which I understand, again, was not negotiated by any of you, nor was Paul on the board at that time, so my comments are not in trying to say anything bad about anyone. The current MOU, for lack of a better word, is just very lean. I'll say it that way. I don't know the role. I don't know if it's, I think it's Kopelman and Page. I'm not sure if they're the ones negotiating the agreement, you know, in concert with Paul and the MWRA. Obviously, there's a board vote with the MWRA and all that kind of stuff. You know, I have reviewed, and I believe it's Quincy, I could be wrong, the only other town that receives money. The impacts that Quincy has on that town, on their town or city, compared to what Winthrop has, there's no comparison. You know, I understand, you know, when Mr. Lasky talked at, you know, one of the meetings, and I'm frank, I'm not sure which one it was, you know, he had talked about, and I think Paul, understandably as well, said, you know, just how hard it is from the board of directors of the MWRA to get everyone to vote on even the, I think it was an 18-month extension that Quincy got on the money they had. And I understand it probably is difficult. So I guess what I'm saying to all of you is the impacts on this town, as all of you well know, are huge. And our current MOU is so incredibly lean. And if you compare, as I have, the MOUs that we have currently today versus the MOU at construction are vastly different. Again, understandably, the first MOU had 2 phases of construction for how the treatment plan was done. There is not enough protection in our current memorandum of understanding, again, MOU. And I guess what I'm just saying to all of you, and I'm not saying that you wouldn't, is we need to really be proactive. And myself and, you know, Dawn and other citizens of our kind of non-formal citizens committee, and every other citizen that I can get involved will help you because, you know, obviously voice and numbers mean something. The MWRA needs to know the impacts on this town are huge. And with the mandates that really pretty much stem from Deval Patrick, or Governor Patrick, I guess I should say, down with regard to how we're now getting to this, you know, pilot program for co-digestion. The plant is now potentially going to be used in different ways. Which again, using the plant in different ways means more trucks for construction to use the plant in different ways. More trucks, hopefully there'll be barges, but there'll still be more trucks that are coming to the plant. And there are just so many impacts that the town of Winthrop has. And it's not just about the dollars. It's not just about the $740,000 or whatever it is. There needs to be more protection in that agreement that currently exists. And I'm not saying that you can make that happen, but as a resident and as a taxpayer and someone who cares, what I'm just urging all of you is to please be involved in this process and please be present in it. And please ask us for help if you need it, to send out letters or whatever it might be. We cannot just allow this MOU to expire in the MWRA to maybe give us another 500 grand for another year or 18 months or whatever it has on the current state of this agreement. It does not have the protection. So I just urge if you guys, which, no guys, sorry, I'm being too informal. I just urge everyone to really be involved in this process. And that's it, thank you.
If you could put some ideas together and forward them to me.
I would love to, I would love
It's
to.
my understanding that it's the town manager's responsibility by charter to negotiate, so it's not the council as a whole.
Yes, and I didn't know whose
No,
role
that's
that
fine,
would be.
but you can forward that to us and we will, or if you can forward it directly to Mr.
I would
McKenna.
happily have a very detailed email to Mr. McKenna.
Pardon me?
I said I would very happily put a very detailed email to Mr. McKenna with my suggestion.
Thank you.
Thank you.
Any further public comment? If not, I'm waiting for a motion.
Motion to adjourn.
Motion to adjourn by Council Boncory, seconded by Vice President Del Vento. Any discussion in the motion? If not, all those in favor say aye. Aye. Opposed? Unanimous. Thank you.